Good morning, everyone. I'm Gent, and I'm a partner in the Cummings and Lockwood's private clients group in the Greenwich office. This morning, I'm going to speak to you about providing an update on the federal and state estate and gift tax laws. Most of you know, legislation enacted in 2017 set the federal estate and gift tax exemption at $10 million indexed for inflation for 2018 through 2025. For gifts made on or after January 1, 2024, the gift tax exemption will shield from gift tax the first $13,610,000 of taxable gifts made during a donor's lifetime that do not qualify for the annual exclusion. For decedents who die in 2024, the estate tax exemption is currently the same figure, $13,610,000, reduced by any gift tax exemption used during lifetime. The generation skipping transfer tax exemption, also known as the GST tax, is also set at the same amount, $13,610,000 in 2024. The maximum estate, gift, and GST tax rates have been permanently set at 40%. And due to the unpredictability, as Laura kind of briefly mentioned, of changes in the estate tax laws, the amount of exemption that will be available in future years is difficult to protect. However, the current law provides the exemption will continue to grow due to the inflationary rate until 2026. Absent further legislation, the estate tax exemption will return to $5 million indexed for inflation in 2026. The 2025 inflation adjustments were announced a few weeks ago. The federal estate and gift tax exemptions will increase, and those figures will be $13,990,000 in 2025. This represents an increase of $380,000 per individual and $760,000 per married couple from 2024. The GST exemption is also increasing due to that inflationary rate adjustment to $13,990,000 in 2025. The value of gifts made by any person that are not includable in the total amount of taxable gifts, also known as the annual exclusion gifts, is $19,000 in 2025. This is an increase of about $1,000 since 2024. The value of gifts made to a non-citizen spouse that are not included in the total amount of taxable gifts for the calendar year in 2025 is $190,000, which is an increase from $5,000 the year before. So immediately following my presentation, my colleague Betsy Falkoff is going to be discussing the potential implications of the U.S. election in November on estate gift and GST transfer tax planning. Portability. The concept of portability was first introduced in 2010, and it was made permanent in the 2012 Tax Act. Portability allows a surviving spouse to elect to save the deceased spouse's unused federal estate tax exemption for the surviving spouse's future use. Currently, only a few states allow for state estate tax portability. Connecticut, New York, and Massachusetts are not one of them. There are several important practice notes to keep in mind with regard to portability. State estate tax may be increased by relying solely on portability. Estate planning is needed to prevent such estate exemptions from being wasted. For example, Connecticut is a use it or lose it state. So if the exemption is not used by the first spouse, the exemption is effectively lost completely. This is where your friendly Cummings and Lockwood attorney can help your clients to plan around this. Keep in mind that the GST exemption is not portable. It's important to note that the exemption transferred to the surviving spouse under the portability regime is no longer available if that surviving spouse remarries and that new spouse also predeceases the surviving spouse. Last but certainly not least, the most important rule with respect to portability is that the portability election can only be made by filing a federal estate tax return. This is extremely important to track because a lot of estates that don't otherwise have to file a federal return, these might slip through the cracks, right? You're not above the exemption, so you're thinking we don't have to file, but you do in order to make that portability election, so it's very key. There has been a revenue procedure ruling that has been released by the IRS that has extended the time for filing a portability only return for 5 years after the decedent's date of death. So there's some wiggle room, but obviously you want to focus on that original deadline is best. As most of you know, Connecticut is the only state that has a gift tax. In 2024, the Connecticut gift tax exemption from tax is $13,610,000 of taxable gifts made over the donor's lifetime that do not qualify for the annual exclusion. This is tied to the federal exemption. It's scheduled to match the federal exemption going forward. In 2024, the Connecticut estate tax exemption is equal to $13,610,000, reduced by any gift tax exemption used during the decedent's lifetime. The Connecticut estate tax exemption is also scheduled to match the federal exemption moving forward. This means that in 2025, the Connecticut gift and estate tax exemptions will be set at $13,990,000. The gift tax rate is a flat 12%. The estate tax rate, the same. New York has an estate tax exemption currently of $6,940,000 for decedents who die after January 1, 2024. New York historically has been late in releasing the following year's numbers, so we don't have the tax adjustments for 2025 quite yet, but we'll release them to you as soon as they're available. Just like the federal estate tax exemption, the New York estate tax exemption is indexed for inflation. So we can expect a little bit of a difference going forward for next year. The top New York estate tax rate is 16%. And the top rate only applies to New York taxable estates over $10.1 million. And estates which are below that amount are subject to tax at graduated rates. The New York exemption is effectively phased out for estates that exceed the exemption amount by more than 5%. So in 2024, that means the value is $7,287,000. This means that for estates that exceed that amount, the entire estate is subject to New York estate tax. This is often referred to as the New York estate tax cliff. If the value of the estates exceeds the New York exemption by less than 5%, however, so this means estates value between 6.94 and 7.287, the decedent only pays estate tax on the difference of that figure, not the whole amount. In circumstances where clients may be subject to the cliff, we have been including in our documents what's called a Santa clause, and it's supposed to save that number so that there's no tax at that time. So the Santa clause is a conditional bequest in a will or a revocable trust to a charity that will happen if the estate is valued over that certain amount for that threshold, so that you don't have to go over the amount and the entire estate is subject to estate tax. There is constantly proposed legislation to remove the cliff and increase the exemption, but these bills haven't been gaining traction as of yet. But again, we'll keep you updated with client updates if we hear anything development-wise on this. New York has a clawback rule. So New York does not have a gift tax. However, gifts made within 3 years of a decedent's date of death are brought back into the estate for purposes of calculating the New York estate tax. This is often referred to as the clawback. It was originally designed to prevent wealthy New York clients from making gifts right before their death to avoid New York estate tax. Essentially, because there's no gift tax, there was a trend for large deathbed gifts, and the clawback was implemented to combat this, basically. While making these gifts is still a very effective technique to transfer wealth, you and your clients should be very conscious of their age and health prior to having these discussions on making these gifts. And care must be taken to explain that the estate tax ramifications if the client dies within 3 years of making those larger gifts. I know we talked about this briefly last year because this was kind of a headline, but in October 2023, the Massachusetts governor signed a tax relief package that retroactively increased the Massachusetts exemption from $1 million to $2 million. It also changes the way that the estate tax is calculated. So as mentioned, in addition to doubling the estate tax exemption itself, the tax relief package changed the way in which the estate tax is calculated. Previously, Massachusetts also had an estate tax cliff, much like New York, where as soon as the decedent's estate was valued over the Massachusetts exemption amount of $1 million, the decedent lost the benefit of that $1 million exemption and was subject to estate tax on everything. The new law, however, gets rid of that cliff, and so each of the decedent in Massachusetts has the benefit of using that $2 million exemption. So this concludes your 2023-2024 estate and gift tax update.